Mic check, mic check. Good morning, everyone. As a kind reminder to those in the room, if I get your attention, please. Testing 1, 2, 3, testing 1, 2, 3. Fantastic. If you're registered to speak today, please make sure that the microphone is on by pushing the button. The little light should be on. If it is not on when you come up to the podium, just go ahead and push the button. And also make sure you push the button before you leave the podium so that it mutes the microphone for the room to get any unwanted chatter or sounds in the background. Also, if you are on the ED side today this morning, make sure the microphone is at least 6 inches away. If you are too close to the microphone when speaking, you will get some distortion on the broadcast. So please make sure that we can hear you clearly and that you're not too close to the mic. Thanks.
Katarina, can you hear us?
Yes, I can hear you now.
Thank you. Well, good morning and welcome to the June 17th, 2026 meeting of the Texas Commission on Environmental Quality. It is 10:31 a.m. I'm joined by my colleagues, Tanya Miller and Katarina Gonzalez, Mary Smith, our General Counsel, and our interim Public Interest Counsel, David Timberger. For each item that argument or discussion is allowed, we will inform parties or the public of time limits for their discussion. Registration closed at 9:30, but if you would like to address the commission on a particular item, please either visit our registration table if you're here in person, or if you're on the webinar, email us at agenda.tceq.texas.gov with your name, affiliation, and the item you would like to comment on, and we will do our absolute best to accommodate your request. For those making presentations, please wait to begin your presentation until I have asked you to begin speaking, and please, please, please mute yourself before proceeding. All right, Mary, first item.
Item number 1 is the consideration of the application by 636 Denton Dev Company, LLC, for new TIPD's permit number WQ00166320001. The parties have been notified that the commissioners will not take oral argument, but may ask questions. Those who have signed in will be noted for the record, and I believe we have a pending motion to remand on this one.
Yes, thank you. I understand that the sole hearing requestor has withdrawn its hearing request and that the ED has filed a motion to remand this morning. So I will take that motion up first and state that I am in favor of remanding this item to the ED so it can be processed as an uncontested application. Tanya, any thoughts?
Agreement.
Katarina?
I agree.
All right. I move that we remand the application to the ED for further processing in light of the withdrawal of all hearing requests. Do I have a second? Do I have a second?
I second.
All those in favor say aye.
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 Thank you. All right. Let's go on to number 2, please.
Item number 2 is the consideration of the petition for the creation of East Ridge Municipal Utility District of Cook County. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
All right, item number 2. In this matter, the commission is reviewing the petition for the creation of the East Ridge Municipal Utility District of Cook County and a request for additional road powers. The proposed district is approximately 454 acres of land wholly within Cook County. One hearing request was filed by the City of Valley View. In reviewing the city's hearing request in accordance with the affected person requirements in 30 Texas Administrative Code Section 55.203C, I find that the City of Valley View does not qualify as an affected person in this matter because it fails to provide sufficient detail regarding the issues it raised, including information explaining where its wastewater treatment facility is located in relation to the proposed district. In addition, the city does not mention or sufficiently explain any statutory authority over or interest in the issues raised. Therefore, the city fails to qualify as an affected person in this matter. So I deny the City of Valley View's hearing request. With respect to the technical review of the petition for the creation of the district, I have reviewed the petition and the supporting documentation and find that the requirements for the creation of the district and the additional road powers have been met. I would further note that the petitioner is bound by the representations made in its petition to the commission, and that is very important. Do I have a motion?
I move that we deny all hearing requests grant the petition for the creation of East Ridge Municipal Utility District of Cook County and grant it additional road powers, and issue the executive director's proposed order for creating the district, granting it additional road powers, and appointing the 5 proposed temporary directors.
Thank you. Do I have a second?
I second.
All those in favor say aye.
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 Thank you. Motion passes.
Item number 3 is the consideration of the application by Paloma Wastewater LLC and MJD Endeavors LLC for new TCEQ permit number WQ00166613001. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
Can you hear me now? Good. Before us, we have an application for a new Texas Land Application Permit, or TLAP, that would authorize the disposal of treated domestic wastewater at daily average flow not to exceed 103,500 gallons per day via surface irrigation of 29 acres of public access land in the final phase. The Commission received hearing requests from numerous individuals and one request for reconsideration. When considering hearing requests in these types of applications, the Commission considers a two-step analysis. First, we determine whether a hearing requester is an affected person. Second, we determine whether an affected person raised issues in their hearing requests that were referable to our friends at SOA. So let's begin with effectiveness. To be considered an affected person, the requester must explain how to be affected by the application in a way that is not common to the members of the general public. The hearing requester must also file timely comments in hearing requests that identify their personal interests and the concerns that they have. Finally, the identified concerns must be within the Commission's jurisdiction to address in the authorization. Turning to the individual hearing requesters in this matter, I believe that we should grant the hearing requests of Kelly Braun, Edwin R., and Alex Ann Power, Helen Ruth Kendig, Ton Raymond, and Catherine M. Hansen, Two Wishes Ranch LP, Mike Reeves, Harry G. Simmons, Rose E. McDonald, Walter S. Benson III, Aubrey Nolte, and Patricia Louise Locke. Taking into consideration the volume of the proposed land application and the issues that these individuals raise in their hearing requests and their close proximity to the proposed facility and disposal site, I believe that they have shown that they may be personally affected by this application in a manner that is not common to the general public. Additionally, I agree with OPIC that we should grant the hearing request of Susan Reeves. Considering these concerns that she raised in her hearing request regarding health, runoff, and impact to her stock tanks and surface water on her property, the volume of proposed land application, and her close proximity to the proposed facility and disposal site, I believe that she has shown that she may be personally affected by this application in a manner that is not normal to the general public. I'll stop here and see where my fellow commissioners land on effectiveness. Tanya?
I'm in agreement.
Katarina?
I'm in agreement as well.
Wonderful. Moving to the second part of our analysis on issues, affected persons raised relevant and material issues regarding substantial completeness and accuracy of the application, health and safety, protection of surface water and groundwater, siting, and buffer zone requirements. These issues are within our jurisdiction to consider for TLAP, so I'd send these to SOA. I'd also deny Kelly Braun's request for reconsideration because her request does not raise new and relevant and material information for the commission to consider it. And finally, I would recommend an 180-day hearing duration. All right, Tanya, are you good?
I'm in agreement.
Sorry, my allergies are horrible today. Katerina?
I'm in agreement, and my allergies have morphed to bronchitis, so that is why I'm sitting in my office.
I'm so sorry. All right, do I have a motion?
I move that we grant the hearing requests of Kelly Braun, Susan Reeves, Edwin R. and Alex Ann Power, Helen Ruth Kendig, Todd Raymond, and Catherine M. Hansen, Two Wishes Ranch LP, Mike Reeves, Walter S. Benson III, Harry G. Simmons, Rose E. McDonald, Patricia Louise Locke, and Audrey Nolte. That we deny the Kelly Braun's request for reconsideration. Refer the matter to SOA for a contested case hearing on the following issues: whether the application is substantially complete and accurate to support the draft permit, whether the draft permit is protective of the health and safety of the requesters, their families, and livestock, whether the draft permit is protective of water quality by preventing wastewater effluent from discharging into surface waters or adversely affecting groundwater, and whether the draft permit complies with applicable buffer zone and site suitability requirements as set forth in 30 TAC Chapter 309, and set the maximum duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
Do I have a second?
Second.
All those in favor say aye.
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 Thank you. The motion passes. Moving on to number 4, please.
Item number 4 is the consideration of the application by the Port of Corpus Christi Authority of Nueces County for water use permit number 13902. The parties have been notified that the commissioners will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
Right. They're trying to find me a cough drop right now. All right, item 4 is a water use permit application that involves diverting seawater from a diversion point located approximately 1.3 miles offshore in the Gulf. The commission must consider effectiveness analysis established in our Chapter 55, Subchapter G rules. I agree with the ED, OPIC, and the applicant that the commission should deny all hearing requests because none of the submissions identify any particularized uses or interests that demonstrate that they will be affected directly than the general public. As such, I'd grant the application by the Port of Corpus Christi and issue the water permit number 13902 in the form recommended by the executive director. Colleagues?
I'm in agreement.
I'm in agreement too.
Thank you. Do I have a motion?
I move that we deny all hearing requests, grant the application filed by Port of Corpus Christi Authority of Nueces County, and issue water use permit number 13902 in the form recommended by the executive director.
Thank you. Do I have a second?
I second.
All those in favor say aye.
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 Motion passes. Thank you.
Item 5 was remanded to the ED on June 12th after the sole hearing requester withdrew their request, so I'll move on to item 6 and give everybody a moment to get up to their desks before calling the item. Okay, item number 6 is the consideration and hearing on an application from Medina County Freshwater Supply District number 5 for additional wastewater and drainage powers. For this, there are presentations allowed. We will begin with the district, who may present its application for additional powers, followed by any interested persons. Presently, we don't have anyone signed in. to address the commission, the ED and OPIC. Each person will have 5 minutes to address the commission. The district may reserve time for rebuttal as it bears burden of proof on its application for additional powers. First, I'll invite a representative from the district. I don't see anyone signed in, but if there's someone here that would like to present their petition. Seeing none, again, as I mentioned, there was nobody signed in to address the commission, so we'll move on to the ED.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Catherine Fisher, and I'm an attorney for the TCEQ Environmental Law Division, representing the Executive Director. With me is Justin Tack from the District Section. The Commission received an application from Medina County Freshwater Supply District Number 5 requesting the approval of additional powers to provide wastewater and drainage services as provided in Texas Water Code Section 51.331 and 30 Texas Administrative Code Section 293.15. Based on a review of the application and supporting documents, the district's request to include wastewater and drainage facilities is feasible and practical, will benefit the land, and will further public welfare. Therefore, the ED requests that the Commission issue an order granting the district's request for additional powers to provide drainage services and wastewater services. Thank you, and we are available to answer any questions you may have.
Thank you. David?
Good morning. Good morning, Chairwoman, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. For the record, I'm Jessica Anderson on behalf of the Office of Public Interest Counsel. OPIC has reviewed Medina County Freshwater Supply District Number 5's request for additional powers to provide wastewater and drainage services to its customers in accordance with 30 Texas Administrative Code Section 293.15 and Texas Water Code Sections 51.331 and 51.332, and respectfully recommends granting the request. The district's acquisition of wastewater and drainage powers is necessary to serve the proposed development within the district and will benefit the land within its boundaries. The proposed wastewater and drainage construction should have no adverse impact on land elevation, subsidence, groundwater levels, recharge capacity of groundwater sources, natural runoff rates, or water quality. Additionally, the district has not previously issued bonds and has no outstanding debt. Notice of this hearing, as required by 30 Tax Section 293.15C1, has been satisfied by publication in the San Antonio Express News on May 20th, 2026 and May 27th, 2026. Additionally, a copy of the resolution requesting addition of wastewater and drainage powers was submitted to the City of San Antonio at the same time as it was submitted to the TCEQ pursuant to 30 Texas Administrative Code Section 293.15H2. Based on a review of the application and supporting documents, the district's request to have the authority to provide for the purchase, maintenance, and operation of wastewater and drainage facilities for its customers is considered feasible. Thank you, and I'm available for any questions.
Thank you very much. Before us today, we have the district's request for an approval of additional wastewater and drainage powers. I've reviewed the backup materials in this matter, and the district has met all the requirements to be granted these powers. The proposed order looks good to me. Tanya?
Agree?
All right. Katarina? Do I have a motion?
I move that we grant Medina County Freshwater Supply District Number 5's request for approval of additional wastewater and drainage powers and issue the Executive Director's proposed order.
Do I have a second?
Second.
All those in favor say aye.
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 The motion passes. Thank you. All right, Mary, next item.
Item number 7 is the consideration of material changes to contracts for goods and services awarded under Chapter 2155 of the Texas Government Code executed between December 1st, 2025 through February 28th, 2026. And the Executive Director's staff is here to present this item.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Roger Doobie, Purchasing Supervisor of the Financial Administration Division. With me, I have Chris Gobert, the Procurement Manager of the Financial Administration Division. We're representing the Executive Director. This item contains the material changes made to the contracts and purchases for goods and services between December 1st, 2025 and February 28th, 2026. Reported material changes include extensions of contract or completion of work for 6 months or more, or an increase of consideration of 10% or more. In accordance with Section 2155.088 of the Government Code, the Executive Director presents these items for your consideration. I'm available for questions you may have.
Thank you so much. Any questions?
No questions?
Well, thank you. Do we have anyone signed in?
We don't have anyone signed in.
OPIC?
Good morning, Chairwoman, Commissioners, General Counsel, and ED staff. For the record, I'm David Timberger, Public Interest Counsel. OPIC has reviewed the material changes submitted for acknowledgement and appreciates the efforts of the ED staff. Thank you.
Thank you, David. Thank you for this report. I've reviewed the resolution acknowledging the material changes in contracts and the supporting material filed as backup, and I'm ready to approve the issuance of this resolution. Tanya?
I agree.
Katarina?
I agree as well, but I just want to highlight one contract from this report because I had the opportunity to visit the Online Bio Nature Center and see the impact that the Restore Act grant and related contract have on the area. That funding is used to restore and protect the natural resources, ecosystems, fisheries, marine and wildlife habitats, beaches, coastal wetlands, and economy of the Gulf Coast region. It's a great area to visit, and I'm really proud of the work our agency has done through this contract.
I love hearing that. Do I have a motion?
I move that we approve the issuance of the Executive Director's proposed resolution acknowledging the material changes to contracts for goods and services as described in TCEQ Inter-Office Memorandum to the Commissioners and Executive Director dated June 17, 2026, and docket number 2026-0477-MIS.
Do I have a second?
I second.
All those in favor say aye.
Aye.
Aye. Thank you. The motion passes. Let's go to enforcement docket.
So the enforcement docket are items 8 through 42, and the Executive Director is here to present these matters.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Megan Hamilton of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 8 through 42. The total assessed administrative penalties are $1,432,173, with $195,989 deferred. $640,555 applied towards supplemental environmental projects, and $595,629 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you. Any questions?
None from me.
Do we have anyone signed in on this item?
So on items 11, 12, 28, and 39, we have people signed in and available for questions. And then we also have interested persons who have requested to address the commission on number 19. So on these items, to allow enough time for all who wish to be heard during the meeting, the commission will limit initial comments from each speaker to 3 minutes and extend that time if the commission needs further discussion with the speaker. And so with that, we'll begin on number 19 with Michelle McKenna. give it to her.
Okay, thank you. Good morning, Chairwoman, Commissioners, and General Counsel.
Good
My
morning.
name is Michelle McKenna, and I am here as a parent of 2 children of Austin Waldorf School. I want to thank TCEQ regional staff for their diligent investigation for bringing this enforcement order forward. We do not challenge the agreed order. We support it. I'm here to respectfully ask for rigorous oversight during implementation so that our children and staff who continue to experience these odors receive meaningful relief. This case is unique because of the absolute physical proximity. We are not discussing odors in an industrial corridor. As shown on slide 2 and the photos that I provided, this manufacturing operation is approximately 50 feet from classroom doors and outdoor learning spaces. 50 feet. That is the length of just 4 parked cars. Students attend school here 5 days a week because the property sits in the ETJ. It was not subject to zoning review that might otherwise have considered compatibility with a neighboring school. While TCEQ's enforcement case appropriately focuses on the nuisance standard under 30 TAC section 101.4, I want to explain what those odor conditions meant for the children, teachers, and staff who experienced them. Throughout this school year, students, teachers, and staff repeatedly reported headaches, nausea, dizziness, and throat irritations during events. My own daughters have had to be picked up early because of severe headaches and stomach pain on high odor days. Children cannot simply leave when exposure occurs. They are in school, they don't have a choice. The investigation has already established the violation. Today's vote is about moving forward. The enforcement timeline has been measured in months. The exposure has been measured in school days, hundreds of them. The next critical phase begins when the commission votes. The facility must submit and implement an odor control plan. The effectiveness of that plan will determine whether this matter is truly resolved or simply prolonged. We have 3 respectful requests. First, require a rigorous odor control plan that relies on specific engineering controls capable of eliminating the nuisance conditions documented by the TCEQ, not vague best practices language. Technologies such as activated carbon filtration and negative pressure containment are examples, but effectiveness should be the standard. Second, maintain active oversight during the 180-day implementation window and treat ongoing community logs and complaints as active verification data. And third, if the facility fails to comply with the order or continues to create nuisance odor conditions, we ask that TCEQ move swiftly to pursue the additional enforcement remedies available under Texas law. Children deserve clean air while they learn. Please ensure what happens after today's vote is worthy of the trust our community has placed in this process. Thank you.
Thank you, Michelle.
Next, we have Mystic Rosa. I believe that.
Good morning. My son, Emerson Rosa, is a 2nd grader going to be 3rd grader at Austin Waldorf. As recently as April 17th, the school hosted a spring festival event with several hundred individuals who were there on a Saturday. My son, elder son, and younger son and husband were there for about 45 minutes. This is a weekend. We were told that this facility is no longer operating during school hours. However, over the weekend, they were firing at all full cylinders. Within the hour, we all had headaches. We had a taste in our throats, a feeling of something, kind of like dripping in the back of our throats. We all left, and at the end of the day, I noticed that all of our clothes smelled like this orange kind of scent, and we were all extremely sick over the weekend because of it. I asked my older son Emerson, who attends Austin Waldorf, this is the smell that he's talked about before, and he said, yeah, this is the same exact smell, which makes me believe that if we're smelling it, we're tasting it, then this compound is falling onto the soil of the property as well, which is a nuisance. This Austin Waldorf is a very special school. One of the reasons why we don't want to pull him from attending there, one of their pedagogy is that kids get an additional amount of play, and it's play-based program. So that means they're outside. That means they're in contact with the soil, with the trees, with the land, and that means they're, being kids and running around and getting a lot of activity and breathing in the air that's surrounding them. So this is a huge concern for us, whether this facility operates during school hours or if it operates over the weekend. Our kids are still coming to school on Monday morning with all of this compound surrounding them. So thank you very much for your time, and that's all I have to say.
Thank you very much.
And then next we have Dr. Michelle Perkart.
Good morning. Today I'm here speaking on behalf of students, families, faculty, staff.
All right, will you hold for 1 second?
Sure.
Thank you. All right.
Hi, so today I'm here speaking on behalf of students, families, faculty, staff, and our board with an ongoing issue that's affected our school for an extended period of time. The ongoing nuisance orders originating from the Wholesale Kings Kratom processing facility located directly behind our campus. Our school's mission really is to provide a safe, healthy, nurturing environment where students can learn, grow, and thrive. Unfortunately, these persistent odors coming from the neighboring facility have created conditions that have been inconsistent with that mission. The issue is not based on isolated incidents or occasional complaints. It represents a documented pattern spanning more than a year. Since May 2025, our school has maintained records of odor events and the corresponding health complaints reported by students, teachers, staff, parents, and volunteers. During these episodes, members of our community have consistently reported headaches, nausea, dizziness, sore throats, stomach aches, itchy eyes, rashes, and migraines. On May 2nd, 2025, 4 of our faculty members reported strong odors and accompanied headaches and sore throats, some of them needing to go home. On May 12th, 2025, 13 faculty and staff members reported strong odors along with headaches, nausea, dizziness, and sore throats, affecting adults and students. Again, a teacher was forced to relocate a classroom outside because the conditions were intolerable. On May 20th, 13 faculty and staff again reported strong odors, headaches, nausea, and rashes. The following day, 3 faculty and staff, who are also parents, reported that their children had come home with headaches for some time. Another staff member reported a strong odor and headache on campus that day. The problem consistently occurred throughout 2025 and 2026. In August 2025, a 3rd grade teacher reported a strong citrus odor. 2 students had to leave because of stomach aches, and another teacher reported that her child returned home suffering from nausea and a headache. The next day, 4 faculty and staff members reported strong odors. Multiple students complained of itchy eyes, sore throats, stomach aches, and headaches. In September 2025, additional reports were received from staff, students, parents, and volunteers about a strong nuisance odor, headaches, dizziness, nausea, and stomach aches. On September 29th, 2025, a parent volunteer reported leaving campus early because of the exposure to the odor, having again a headache. In October 2025, staff members reported headaches, nausea associated again with this strong odor. 1 student left school with a headache and nausea symptoms. Staff document.
I'd like to give her a few more minutes. 2, please.
Thank you. Also, equally concerning is the impact on the school community and enrollment. One faculty in our kindergarten specifically unenrolled their child because of the kratom odor issue. Another family with 3 children withdrew because they were concerned of the impact of the factory on the health of their children. Another 7 students whose families left the school this summer identified the odor as a problem, and that's influenced their decision to leave. So many families continue to express frustration and concern about this issue. We're increasingly worried that the continued exposure and continued uncertainty could result in additional withdrawals and health issues for our children and our faculty. Importantly, these concerns have been validated by the Texas Commission on Environmental Quality, as Michelle has already stated. And what we're really asking is that we take this seriously, that there's continued investigation and oversight of the facility and the operations and emissions, and verifications that all requirements of the TCEQ enforcement order and order control plan have been fully implemented and functioning as intended.
Thank you very much. Any others?
No one else has signed in.
All right, OPIC.
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Directors, Attorney, and staff. For the record, I'm Pranjal Mehta for the Office of Public Interest Counsel. Our office has reviewed these items. OPIC also acknowledges the comments and concerns raised today. After review, we recommend approval of all items. We thank the ED staff for the hard work on this.
Thank you. Well, I've reviewed the talking orders and reviewed the orders and supporting materials, and I'm prepared to move forward to adopt them. As always, I appreciate all the hard work that goes into getting these orders ready for agenda. Colleagues, I'm sure it's the same.
I agree.
Yeah. Katarina?
Also, I just want to note that it looks like more than half the orders are accompanied by a supplemental environmental project today, and so I want to thank our SEP program staff for the work they do for our agency.
Thank you. Do we have a motion?
I move that we adopt items 8 through 42 as recommended today by the Executive Director.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Aye. Thank you. The motion passes. Let's move on to the monthly enforcement report.
Okay, yes, item 43 is the monthly enforcement report, and the Executive Director's staff are here to present this.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Sedemeyer of the Enforcement Division, and with me are Megan Hamilton of the Enforcement Division and Katanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2026 through April. There were 1,051 effective administrative orders issued, and of those, 177 contained supplemental environmental projects. These orders assessed a total of $18,697,321 with a payable amount of $10,345,018.73. $5,776,914 are to be paid towards supplemental environmental projects. 11,116 notices of violation have been issued either through our field offices, a review of self-reported data in our central office, and 872 enforcement action referrals have been received. There are 2,582 pending administrative orders. 156 cases are pending at the Attorney General's office for representation in district court, and 9 judgments have been issued. 1,759 cases are being tracked for compliance. Currently, there are 1,086 cases that are on the backlog, which represents a reduction of 144 cases since last month's report.
Additionally, with today's agenda, we will have issued 1,376 cases this fiscal year, and of those, 495 were backlogged at the time of issuance. Within the division, we continue to push towards real-time enforcement and have made significant strides in this area. We're available to answer any questions you may have.
Amy, the strike force is doing exactly what it was supposed to do. Christy, well done. Thank you for the report. And Mary, has anyone signed in on this item?
Yes, we have Catherine Guerra signed in on this one.
Good morning, Commissioners. Can you hear me?
Yes.
I'm Catherine Guerra with Public Citizens Texas Office. I serve as Director of the TCEQ Watchdog Campaign and Agency Accountability and Community Capacity Building Initiative. We have been tracking the agency's enforcement case backlog. The last Commissioner's agenda had 50 enforcement cases resolved. I think that's the most that we've seen recently. Today you have 30 more on the docket. We want to commend the agency's staff on their progress, closing those enforcement cases with an agreed order that binds the respondent to compliance deadline and imposes a penalty. We are still concerned about the number of cases being closed without an agreed order. We have several months now of enforcement backlog data that we've received in response to our request under the Texas Public Information Act. In February, 32 cases were closed or non-suited. In March, 13. In April, there were another 23. That's nearly 70 cases. Unfortunately, in some of the non-suited or withdrawn cases, it appears TCEQ just waited too long to send the proposed agreed order and the business closed or transferred hands, and the responsible party couldn't be found after so much time had passed. Non-suiting cases negates the work of the agency's investigators. They found violations egregious enough to rise to the level of enforcement action, but there won't be any accountability, and ultimately that is a system failure. Some of the closed enforcement cases for which there was no agreed order or penalty were for serious environmental disasters. For example, in Fort Worth, TCEQ alleged that in December of 2019, the U.S. Navy spilled approximately 2,600 gallons of PFAS containing 3% aqueous film-forming foam, or AFFF solution, which is a synthetic firefighting concentrate used to extinguish fuel fires, from an above-ground tank directly into the storm drain at the Naval Air Station Joint Reserve Base. That spill contaminated a local creek, but TCEQ says the Navy failed to contain the spill or respond to the pollution. TCEQ requested sampling of the impacted creek, but the Navy did not respond. The city of Fort Worth is suing the U.S. Department of Justice for contaminating the city's drinking water with PFAS, which they allege came from the use of that firefighting foam from the Joint Reserve Base. TCEQ closed that enforcement case in February after 6 years, seemingly without requiring sampling, remediation, or the payment of a penalty. Last month, it appears the agency closed 2 air enforcement cases against Chevron Phillips Cedar Bayou plant, a habitual violator of their air permits. Those enforcement cases from 2022 and 2025 without any clear resolution. We previously requested information on how those cases are being closed, and we were told that the agency didn't have to provide that information. So while we're encouraged and appreciate the TCEQ's new resolve to address its enforcement backlog, the public does deserve transparency and accountability. We have published a summary of the agency's efforts on the backlog on our website that further breaks down how those cases are being handled, and we will continue to monitor which cases the agency closes without seemingly any resolution, and which cases result in actual progress for communities and accountability for polluters. Thank you.
OPIC?
Good morning, Chairwoman, Commissioners, General Counsel, ED staff. For the record, I'm David Timberger, Public Interest Counsel. OPIC has reviewed the April enforcement report and appreciates the significant efforts of ED staff to accomplish the work that they've accomplished. Thank you.
Well, again, Amy, Christy, the whole gang, y'all have done an amazing job. The strike force is working. No action is necessary in this item, but Tanya, Katarina, do you have any thoughts or comments?
Just as always, thank you for your hard work. Appreciate it.
I have a few comments. I just want to highlight that the backlog orders have decreased by 144 since last month. And I noticed that the total number of backlog orders is considerably below that of 2024 and 2025. And based on the last 17 months of data, that those orders are consistently trending downward. I really appreciate staff's hard work and demonstrated improvements and all of that hard work that the enforcement coordinators and leaders within the division are doing. Also want to note that the enforcement report states that 177 supplemental environmental projects have been approved during fiscal year 2026 through April 2026, which I think is a really great thing.
Great thoughts. Thank you.
Thank you.
Let's move on to rules.
Okay, that brings us to item 44, which is the consideration of the adoption of amendments to 30 Texas Administrative Code, Chapter 328, regarding waste minimization and recycling. And the Executive Director's staff is here to present this item.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Jarita Sepulvedo with the Waste Permits Division. With me is Matthew Hopper with the Environmental Law Division. The adopted rulemaking would implement House Bill 4413 from the 89th Texas Legislature, which required the Commission to adopt rules identifying third-party mass balance attribution certification systems for the identification of renewable chemicals. The rules would fulfill the legislative directive by amending Title 30, Texas Administrative Code, Sections 328.301, 328.302, and 328.304. The proposed rules were published in the January 2nd, 2026 issue of the Texas Register. A hybrid public hearing was held on January 27th, 2026, and the public comment periods closed on February 3rd, 2026. The rule team received public comments and made no changes to the proposed rules in response to the comments. Staff respectfully recommends adoption of this rulemaking to Chapter 328, Waste Minimization and Recycling. Additionally, staff requests authorization to make non-substantive revisions to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you so much. Any questions?
No.
Is there anyone signed in on this item?
No one signed in on this one.
All right, David?
Good morning, Chairwoman, Commissioners, General Counsel, and the Executive Directors, Attorney, and staff. For the record, I'm Pranjal Mehta for the Office of Public Interest Counsel. Our office has reviewed this rulemaking. It implements House Bill 4413 by expanding the purpose of 30 TCEQ Chapter 328 to include renewable chemicals under the existing mass balance attribution framework. Under that framework, renewable or recycled material can be tracked through a certified accounting system for the purpose of identifying renewable chemicals. In simple terms, mass balance attribution is an accounting method used to track renewable or recycled material throughout the manufacturing process when materials are mixed and cannot be physically traced in the final product. The rule adoption makes three main changes. First, it updates the purpose section to include renewable chemicals within the existing framework for recycled products and mass balance attribution. Second, it adopts the definition of renewable biomass and renewable chemical. It also amends the definition of mass balance attribution and recycled material to include a renewable chemical. Third, it allows renewable chemicals to be included when determining the minimum content of a recycled product through a third-party certification system. OPIC understands that this rulemaking does not create new requirements or obligations for the regulated community, but it may incentivize the use of more biomass materials in manufacturing processes, diverting these materials from disposals in landfills. Comments were received from Air Alliance Houston, Environment Texas, and one individual. The comments generally raised concerns about chemical recycling and specific mass balance attribution methods. OPIC agrees with the response to comments that the rulemaking does not select or advocate for any specific third-party certification system or mass balance methodology. For these reasons, OPIC supports rule adoption. Thank you.
Thank you so much. I believe this rulemaking stays true to the legislative intent. I'm ready to move forward. Colleagues, agree?
Agree.
All right, do you have a motion?
I move that we adopt the amendments to 30 Texas Administrative Code, Chapter 328, as recommended by the Executive Director.
Do I have a second?
I second.
All those in favor say aye.
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 Thank you. The motion passes. Move on to number 45.
Item 45 is the consideration of the adoption of amendments to 30 Texas Administrative Code, Chapter 293 regarding water districts, and the Executive Director's staff is here to present this item.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Cindy Hooper with the Water Availability Division, and with me today is Cole Malley with the Environmental Law Division. The rulemaking adoption before you will amend 30 TAC Section 293.23 and will implement the provision of the House Bill 2080, which was passed during the 89th Texas Legislature's regular session. HB 2080 amended Section 36.3011 of the Texas Water Code relating to petitions for inquiry into the actions of a groundwater conservation district, or GCD. The bill added requirements regarding a review panel appointed by the Commission under this section, and this rulemaking adoption implements those changes. The proposed rule was published in the January 30th, 2026 edition of the Texas Register. A hybrid public hearing was held on February 24th, and the comment period closed on March 3rd. We received comments from 2 individuals and 1 GCD. All commenters expressed support of the rulemaking. No changes were made to the rule as proposed. Staff respectfully recommends approval of the adoption of amendments to 30 TAC Section 293.23, and we respectfully request permission to make non-substantive changes to comply with Texas Register requirements. Thank you, and we're available for questions.
Thank you so much. Any questions?
No questions.
Mary, anyone signed in?
No one is signed in.
All right. OPIC?
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. For the record, I'm Mike Orkauskas on behalf of OPIC. OPIC has reviewed this rule amendment proposal and respectfully recommends adoption, as this amendment has been created by statute. This proposed amendment of 30 TAC Chapter 293, Water Districts, Subchapter C, Special Requirements for Groundwater Conservation Districts, Section 293.23, implements House Bill 2080 by clarifying agency process and rule, the processes and rules requests received by the Commission for inquiries into groundwater conservation districts. The proposed amendment would clarify multiple parts of Section 293.23, including the status of the review panel as an advisory board and not a governmental body, the role of the recording secretary in the review panel, notice requirements, and the role of technical and legal advisors to the review panel. This amendment would clarify the rules governing the review panel for groundwater conservation districts. The amendment would also elaborate on what resources are available to the review panel members to assist with the review of a petition requesting commission inquiry. The statute directs the commission to reimburse actual expenses of review panel members incurred while engaging in activities on behalf of the review panel. OPIC notes that there are no limitations on the amount of reimbursement, so it will be incumbent on the program to ensure that they are reasonable and necessary before they are incurred and consistent with the Appropriations Act. OPIC further notes that while neither the statute nor the Appropriations Act identify a funding source to pay these expenses, they are not anticipated to be significant. These expenses would also be paid from existing agency funds. The adoption of this rule also allows review panel members to seek technical assistance from Water Development Board staff and legal advice and assistance from TCEQ's Office of Public Interest Counsel. Because OPIC would serve as a legal counsel for the review panel, OPIC would no longer serve in its traditional role of representing the public interest as a party in GCD inquiries before the commission. The statute and rule are explicit. OPIC may not participate as a party in an inquiry, and OPIC has no duty or responsibility to represent the public interest or otherwise in an inquiry, except as otherwise provided by the statute. Thank you, and I'm available for questions.
Thank you so much. Any questions?
No questions.
Nope. All right, in my review, the Chapter 293 rule amendments appropriately implement House Bill 2080 as passed by the 89th Texas Legislature. I always appreciate staff's work on this rulemaking and the public support for this rulemaking as well. I'm ready to move forward in adoption. Do I have a motion?
I move that we adopt the amendments to 30 Texas Administrative Code, Chapter 293, as recommended by the Executive Director.
Do I have a second?
Second.
All those in favor say aye.
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 All right, we'll move on to items 46 through 49.
Okay, these are items for closed session. The commission will meet in closed session in room 4222 of Building F at noon, as permitted by the Open Meetings Act, including Texas Government Code Sections 551071 and 551074, to take up and consider matters pursuant to items 46 through 49 as posted and noticed.
Thank you. This meeting stands in recess.
The commission met in room 4222, Building F, for closed session from 12:01 until 12:16 on item number 47 is posted in notice pursuant to Texas Government Code Section 551074. No action was taken. The agenda stands adjourned, and the time is 12:37.